I plead the fifth.
All right, guys, let's get going. Today, we're going to be trying to wrap up the Fifth Amendment. To get us going, I've got a little video we're going to watch.
I plead the fifth. I said there are so many amendments in the Constitution of the United States of America. I can only choose one.
No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
Very good. Okay. So, why do we care? Why is this important? Walt?
It's arguably the most popular of the amendment rights. Most people think they know it, and they have seen it in movies, read about it in books or newspapers. And the thing is, most people don't even know the language of the Fifth, how it came to be, and they will most likely know what it means if they don't have to testify against themselves or they can't be tried twice for the same crime.
First case, Landy Kitts. Is Landy here? Landy?
Two, one, go.
No Landy? Landy's not here? Okay. How about Hank Warren? Hank, are you here?
Yeah, Dean Reed, this is embarrassing, but my Wi-Fi for some reason won't connect. So in Heather Williams versus Robert Kelly, better known as R. Kelly, Heather Williams filed a civil sexual assault case against Robert Kelly. Williams was 16 years old when she met R. Kelly in Chicago. They started having a sexual relationship after Kelly promised her a role in the upcoming music video. Williams claims that Kelly was sexually abusive, and instead of testifying in the case, Kelly pled the Fifth Amendment right not to self-incriminate. One reason Kelly pled the Fifth is because he did not want to incriminate himself in this case or the future cases. He had some criminal cases in New York and Illinois against him, and he did not want to incriminate himself for those upcoming cases. And the judge rendered a default judgment against Kelly in favor of Williams.
All right, very good. Yes, that's exactly what happened in that case. Let's move on to the next one. We've got Martin Shkreli, and I think I've got a video for you guys. Yep, I do. Perfect.
Mr. Shkreli, you did not provide the committee any written testimony. Do you wish to make an opening statement?
On the advice of counsel, I will not be giving an opening statement.
I want to ask you a few questions. What do you say to that single pregnant woman who might have AIDS, no income? She needs Daraprim in order to survive. What do you say to her when she has to make that choice? What do you say to her?
On the advice of counsel, I invoke my Fifth Amendment privilege against self-incrimination and respectfully decline to answer your question.
you were quoted as saying on Fox 5 in New York, you were quoted as saying, if you raise prices and you don't take that cash and put it back into research, I think it's despicable. I think you should not be in the drug business. We take all of our cash, all of our extra profit, and spend it on research for these patients, for other patients who have terrible life-threatening, life-ending diseases. Did you say that?
On the advice of counsel, I invoke my Fifth Amendment privilege against self-incrimination and respectfully decline to answer your question.
Do you think you've done anything wrong?
On the advice of counsel, I invoke my Fifth Amendment privilege against self-incrimination and respectfully decline to answer your question.
I just want to make sure you understand, you are welcome to answer questions, and not all of your answers are going to subject you to incrimination. You understand that, don't you?
I intend to follow the advice of my counsel, not yours.
You gave an interview to a television station in New York where, if I understood you correctly, you couldn't wait to come educate the members of Congress on drug pricing, and this would be a great opportunity to do it. So do you understand you can waive your Fifth Amendment right?
On the advice of counsel, I invoke my Fifth Amendment privilege against self-incrimination and respectfully decline to answer your question.
It is, it's your intention to decline all answers to the questions and invoke your Fifth Amendment right?
Yes.
Given that the witness has indicated that he does not intend to answer any questions, and out of respect for his constitutional rights, I ask now that the committee excuse the witness from the table. Without objection, so ordered.
We just saw two examples of how defendants have pled the Fifth Amendment and invoked their right not to self-incriminate. The second way that we see defendants using the Fifth Amendment when they are being prosecuted in a criminal trial is to their advantage is actually double jeopardy. And it's not so much something the defendant does for itself as it's something our justice system has put in place as a mechanism to protect the defendants. And what we know about double jeopardy is a person cannot be tried for the same crime twice. There are some exceptions to this if there's a hung jury, or in the instance that there's a federal charge in play and the defendant potentially went through at a state court level and that trial has concluded, there's still an opportunity for the federal government to bring about federal charges and could potentially see it go back through in a federal court system. Our first example of a case where double jeopardy came into play, it's a well-known case, is the case of Casey Anthony. Casey Anthony was tried in a Florida court for the death of her 3-year-old daughter, Kaylee. In the year 2008, Kaylee's grandmother, which is Casey's mom, called 911 and said she had not seen the grandchild for 31 days. She also said that she detected an odor of death in the trunk of her daughter's car, and she was very concerned that something had happened to the grandchild and that maybe her daughter was potentially involved. There were a lot of other circumstantial factors that came into play. Potentially, you know, Casey, one, she didn't report her own child missing, who'd been missing for over 30 days. She also lied to the investigators through the course of the prosecution and the information gathering facts of the stage. She said that she had a job that she didn't have, that there was a nanny that had potentially taken her who turned out to be made up. So there was a lot of circumstantial things in play. This particular trial was highly publicized throughout America. Everybody had an opinion on it, and by and large, most people thought Casey Anthony was guilty. One thing that her defense counsel did in the trial is they raised an alternative theory. They said potentially the child did not die through a murder, but possibly a accidental drowning. And what we found out was that was enough for the jury to say they were not convinced beyond a reasonable doubt, and they returned a not guilty verdict. A lot of people thought that she should have been tried again, but double jeopardy has kept her from having to go back through court. So that's one way that unfortunately justice maybe doesn't always prevail, but we'll never know. It's really Only Casey knows, I suppose. All right. How are we doing on time? Are we, yeah, you know what? We got 4 minutes. I think I can get one more case in. Let's do our final case today. Landy Kitts. Did I already call one Landy? Oh, someone else back in. Landy, are you here?
Can you repeat the question?
Yeah. Can you tell us what happened in Simpson? Go.
So in the O.J. Simpson case, this is where he was tried for the murder of his ex-wife, Nicole Brown Simpson, and her friend, Ron Goldman. And he was ultimately found not guilty and acquitted on all the criminal charges. But he was later held liable in a civil trial where the jury said that, I guess by preponderance of the evidence, he was responsible for their deaths. But because of double jeopardy, he cannot be retried criminally because a jury had already acquitted him, even though millions of people, myself included, are convinced that he's guilty. But if the gloves don't fit, you must acquit, according to his lawyer.
Right. Very good, Landy. Good job on that one. Okay, we are out of time, but just one final thought. As you all go, I want you to go out there and be super spreaders of the Fifth Amendment. Super spreaders of the Fifth Amendment. Super spreaders of the Fifth Amendment. Super spreaders of the Fifth Amendment.